For 5 years, Fidelis Wambui worked at Hallmark Marketing right here in Nairobi. She earned a basic salary of 50,000 shillings a month. But Hallmark kept her employment status dangerously informal. They never gave her a written letter of appointment, nor did they provide itemized payslips. That lack of formal protection became a critical issue in March 2021, when Wambui developed severe pregnancy complications and doctors placed her on mandatory bed rest. By April 13th, her condition required an extension. She notified the company's chief executive officer that her doctor ordered an additional 28 days of strict bed rest. This medical vulnerability, combined with the lack of a formal contract, triggered an immediate corporate reaction of hostility rather than support. Exactly 2 days after she requested the medical accommodation, Wambui received a letter from Hallmark placing her on indefinite unpaid leave. The company's official explanation for the suspension was a sudden financial restructuring, which they blamed on the economic fallout of the COVID-19 pandemic. The timing was highly suspect. A sweeping corporate financial restructuring conveniently materialized 48 hours after a pregnant employee asked for medical leave. Furthermore, Hallmark could not produce a single piece of evidence to back up this claim. There were no company-wide redundancy notices, no meeting minutes discussing layoffs, and no general staff communications. Applying a sudden, undocumented restructuring exclusively to a pregnant employee functions legally as a corporate smokescreen. That pretext would eventually be dismantled here at the Employment and Labor Relations Court. The court examined the company's actions on April 19th. That day, Wambui was suddenly ejected from all 21 of her work-related WhatsApp groups. Simultaneously, her official work email was blocked. This digital lockout happened before her scheduled unpaid leave had even officially begun. This aggressive isolation introduced the central legal concept of constructive dismissal, relying on precedent from a previous dispute involving Coca-Cola East and Central Africa. Constructive dismissal occurs when an employer's conduct constitutes a repudiatory breach of the employment contract, entitling the employee to treat themselves as discharged. Severing a worker from all digital communication channels while they are on medical leave demonstrates an intention to no longer be bound by the contract. Legally, the company forced the employee to consider herself fired. In court, Hallmark tried to argue that Wambui was never a permanent employee, claiming she worked on intermittent, client-dependent contracts. But because they never gave her a formal contract, Section 10, Subsection 7 of the Employment Act triggered. This provision forces the burden of proving the terms of employment onto the employer. Since they paid her a continuous salary for 5 years, their defense failed. The court then turned to the ironclad protection of Section 46 of the Employment Act, which explicitly states that an employee's pregnancy shall never constitute a fair reason for dismissal. Under Section 47, Subsection 5, once an employee makes a valid complaint of unfair termination, the absolute burden of justifying that termination shifts entirely to the employer. Because Hallmark failed to produce any corporate minutes or official redundancy notices, their entire defense collapsed under the weight of statutory law. During this forced digital exile and medical crisis, Fidelis Wambui tragically lost her child. The legal analysis moved to the specific protections enshrined in the Kenyan Constitution. The judge ruled that placing her on unpaid leave specifically due to her pregnancy constituted a direct violation of Article 27, which prohibits discrimination. Furthermore, treating a grieving woman facing health challenges as a corporate liability violated Articles 28 and 29, the rights to human dignity and protection from inhuman treatment. The court determined that the intersection of Hallmark's callousness and Wambui's personal tragedy created an actionable human rights violation under Article 23. The court's final ruling was a punitive measure for these combined statutory and constitutional breaches. Standard employment compensation came first: 12 months' salary for unfair termination, house allowance, unpaid leave, and service pay, totaling 1.4 million shillings. Then the court added damages for human rights violations. 3 million shillings slammed onto the total, pushing the final award past 4.4 million. The judge noted that this immense award was calibrated to address the profound personal suffering endured by the employee and to punish the egregious nature of pregnancy discrimination. Ultimately, using a corporate restructure as a pretext to push out a pregnant employee is a multi-million shilling liability.